Singapore is one of the wealthiest, most stable, and most internationally integrated small states on Earth. It is also one of the few countries in the developed world that still applies the mandatory death penalty for drug trafficking. That tension is now at the center of a constitutional fight that could reshape criminal justice in the city-state, and its outcome will reverberate across Southeast Asia. Here is the core issue. Singapore's Misuse of Drugs Act has long mandated capital punishment for trafficking above certain thresholds. In theory, a public prosecutor retains discretion to offer an alternative, life imprisonment, if the accused cooperates with authorities or is certified as merely a courier. Critics argue that this discretionary power, concentrated in the executive branch, is applied inconsistently and without adequate judicial oversight. The constitutional challenge now being mounted targets exactly this asymmetry, the question of whether life or death decisions can legitimately rest with a prosecutor rather than a court. To understand why this matters, you need the historical context. Singapore built its deterrence-based drug policy in the 1970s and 1980s, when heroin addiction was genuinely tearing through the region. The mandatory death penalty was framed as an existential necessity. A small, port-dependent nation with no strategic depth could not afford to become a narcotics transit hub. That logic earned legitimacy domestically, and for decades it was largely unchallenged in the courts. But the legal landscape has shifted. A 2012 amendment created the Prosecutorial Discretion Clause, which was itself a concession to international pressure and domestic advocacy. What critics now argue is that this concession was incomplete. It transferred a life or death decision from an automatic statutory trigger to a single official, without creating enforceable standards, transparency, or meaningful appeal. In a state governed by the rule of law, they say, that is constitutionally untenable. For Southeast Asia, this case has implications beyond Singapore's borders. Several ASEAN members, Malaysia, Indonesia, Thailand, Vietnam, maintain capital punishment for drug offenses, and several operate with similarly opaque prosecutorial or executive discretion. If Singapore's courts uphold this constitutional challenge, even partially, it will set a precedent that activists across the region will immediately cite. The argument that transparency and judicial oversight must govern capital decisions is not a Western import. It is a requirement of any legal system that claims to be grounded in the rule of law. The deeper question this fight exposes is about the relationship between state effectiveness and institutional accountability. Singapore's government has consistently argued that its criminal justice system, including capital punishment, is applied fairly, transparently, and with proportionality. The constitutional challenge does not dispute that Singapore is effective. It asks whether effectiveness is a sufficient defense against a process that concentrates irreversible power in unaccountable hands. Those are very different questions. For small states navigating this issue, the stakes are reputational and legal simultaneously. Singapore's international standing rests partly on being a jurisdiction that foreign investors, trading partners, and multilateral institutions trust implicitly. A credible, well-argued constitutional challenge, even if ultimately unsuccessful, signals to the world that Singapore's own legal community is willing to test its institutions from within. That is not weakness. In a rules-based order, the willingness to subject state power to judicial scrutiny is precisely what distinguishes durable governance from authoritarian opacity. However this constitutional fight concludes, it has already achieved something important. It has forced a public, structured, legal debate about who holds